But Counsel, can I just ask you about this, though? Have we ever applied the spending clause's notice requirement outside of the damages context? Because here we're not talking about a situation in which B.P.J. is seeking damages, and I thought that was sort of a crux of the spending clause analysis.
I will concede, Your Honor, that many of the cases that talk about this rise in the context of, or maybe even all of the cases
yes,
that rise in the context. I'll concede as much, yes, Your Honor, but I don't think the court has ever suggested that the specific request for damages is the reason for its analysis, and I think that actually would be inconsistent.
But we would be having to address that, I guess, and extend it in this context if we were to take a spending clause tack.
I would respectfully disagree, Your Honor. I would say that just because the court hasn't done so before doesn't mean it's an extension per se. I think that what the court has said is that you view the language of these statutes as effectively contractual agreements. And I think that that same sort of contractual logic applies whether you're asking the state to pay out damages or whether you're asking it to take specific action under compulsion of that.
Who is the contract between here? And I thought the regulated party needs to know what it's agreeing to so it can consent, but here the regulated party is the schools and it's the state that's coming in. So I'm just trying to understand how the spending clause analysis works in this context.
So I think the state is certainly one party that does receive federal educational funds, but it's also the many other petitioners that stand before you, including the county school board and the state school board, are also petitioners in this case. I think there would certainly be, if anybody were clearly bound by the conditions of Title IX.
So it would map on. I mean, I guess I'm worried that this
Right.
might actually implicate the question that we didn't resolve in Moyle, and so we'd have to kind of figure that out because it seems like it's a different set of facts than the typical spending clause application.
I think, if anything, Your Honor, this is maybe easier than your typical spending clause analysis because you've got everybody from the state all the way down to the local county school board. Anybody and everybody who's involved in this case is a party to this action. In fact, you resolved a petition for cert from the Athletics Commission saying we're not actually a state actor, and the Fourth Circuit saw things quite differently. So I think there's really no concern in this case that you have an absent actor problem when it comes to the spending clause analysis. And ultimately, of course, if it's just a canon of construction, if you're looking for a clear statement, then I think it would apply regardless of the particular party who might be in front of you because the statute applies across the board. You know, the regulated party is going to be affected regardless of whether they happen to be in front of you in the given case.
Can I ask you